Good morning, this is your Kelso Report for Wednesday, April 17th. I'm your host, Clark Kelso. Apologize for my absence for the last week. It's been a particularly busy time at the law school and in my other endeavors. Well, today we begin with two U.S. Supreme Court decisions, the first involving mootness and the second involving an action under ERISA to enforce an equitable lien. We then turn to two preemption decisions from the Ninth Circuit, the first involving insurance, and the second involving securities law. First, let's turn to the Supreme Court and doctrine of mootness. Our first case involves mootness in the context of a so-called collective action under the Fair Labor Standards Act. The Act provides that an employee may bring an action to recover damages for specified violations of the Act on behalf of himself and others similarly situated. In Genesis Healthcare Corp. versus Simzik, the plaintiff filed a collective action to challenge her employer's practice of automatically deducting 30 minutes for lunch for certain employees, even when those employees worked through lunch. The business answered the complaint and served an offer of judgment under Federal Rule of Civil Procedure 68, offering the plaintiff $7,500 for alleged unpaid wages, in addition to such reasonable attorney's fees, costs, and expenses as the court may determine. The plaintiff failed to respond to the offer of judgment, after which the employer moved to dismiss for lack of subject matter jurisdiction, reasoning that the plaintiff no longer possessed a personal stake in the outcome of the suit in light of the offer of judgment, thereby rendering the action moot. Well, since no other individual had decided to join the plaintiff's lawsuit, the district court granted the motion to dismiss. The Court of Appeals reversed, but the Supreme Court agreed that the case was indeed moot. The plaintiff argued that the employer was inappropriately attempting to pick off the named plaintiff before the collective action process under the Act could unfold. But the Supreme Court rejected the attempt to transform the collective action under the FLSA into a mini class action process similar to Rule 23. As the court explained, after the offer of judgment, the plaintiff had no personal interest in representing putative unnamed claimants, nor had any other continuing interest that would preserve her suit from mootness. Shrewd move by the employer. Next, we turn to an ERISA plan. In U.S. Airways Benefits Plan versus McCutcheon, an employee's health care plan paid medical expenses incurred as a result of a third party's negligence. But the terms of the plan gave the plan the right to reimbursement from the employee if the employee later recovered any money from the third party. Now, the Supreme Court had previously held that a plan in these circumstances may enforce the reimbursement provision by filing a suit for equitable relief under Section 502A3 of ERISA. The issue before the Supreme Court yesterday was whether certain equitable defenses that would have been inconsistent with the express terms of the plan could nevertheless apply to the benefit of the employee. In particular, the employee sought to apply the so-called double recovery defense, pursuant to which an insurer is limited to recovering only that portion of a judgment against a third party that compensates the injured party for exactly the same loss the insurance covered. Under this rule, for example, the insurer could not recover damages for lost wages or pain and suffering if the insurance policy covered only medical expenses. Well, the problem for the employee in this case was that the plan expressly provided that the plan would receive first claim on the entire third-party recovery, inconsistent with the principles of the double recovery rule. The court held that the express terms of the plan prevailed and could not be overcome by the double recovery equitable defense. The plaintiff also argued that the common fund doctrine should apply so that the plan would share proportionately in the cost of the employee's attorney's fees. On the issue of attorney's fees, the plan was entirely silent, so the Supreme Court interpreted the plan consistently with the common fund doctrine. But the major holding here is clear. The terms of the plan apply. Now we have two preemption cases from the Ninth Circuit, the first involving insurance. As a general matter, of course, the law of insurance is a creature of state law instead of federal law. However, there are isolated areas of insurance law where there is some federal law, and when federal law exists, issues of preemption are never far behind. In Alliance of Nonprofits for Insurance versus Kipper, the Ninth Circuit considered the question of whether federal law dealing with risk retention groups preempted an order from the Nevada Commissioner of Insurance that appeared to be in conflict with the Federal Liability Risk Retention Act. A risk retention group is basically an insurance company that only insures the liability risks of its owners. So instead of buying insurance, its insureds become company owners. The Liability Risk Retention Act broadly preempts any state law, rule, regulation, or order to the extent that such law, rule, regulation, or order would make unlawful or regulate, directly or indirectly, the operation of a risk retention group. When the plaintiff insurance company tried to sell first dollar automobile liability insurance in Nevada, it found its efforts frustrated by the DMV and then the Commissioner of Insurance, who refused to issue a Nevada Certificate of Authority to the plaintiff. Applying the plain meaning of the federal statute, the Ninth Circuit held that the Commissioner's action was preempted by the federal statute. By federal law, the plaintiff could do business in Nevada. Our next preemption case involves securities law. California's labor code prohibits employers from requiring that employees patronize his or her employer in the purchase of things of value. However, it's common practice in the securities industry to require employees to open any self-directed account only at their home firms. This rule is intended to help the securities industry police insider trading. In McDaniel versus Wells Fargo Investments, a number of employees sued to set aside the company rules as violative of California's forced patronage law. The companies defended on the ground that federal securities laws encourage securities firms to take affirmative steps to prevent their employees from engaging in harmful or unfair trading practices. The Ninth Circuit agreed with the firms that California's law stood as an obstacle to the effective enforcement of federal securities laws in this regard. And so, California's forced patronage law was held to be preempted with respect to the enforcement of a policy forbidding employees of securities firms from opening outside trading accounts. It seems to me a good decision under the law and a good decision as a matter of policy to prevent securities firm employees from getting themselves in trouble. And that's it for today's Kelso Report. Have a great day in the law.